Welcome back to another episode of Energy 101. We know that it's been a while. We apologize.
Sorry.
We've been busy. If you watched our webinar with Michael Minham Robinson a couple months ago with Chuck, you recognize these two lovely ladies. Lauren and Ashley are two favorite energy lawyers. They are here to school us on everything energy law, energy trial, and why it's important to just kind of be in the know. No one likes to get sued. No one likes to get called to be a part of a trial. So I'm excited to kind of learn how we can protect ourselves and what all goes into being a part of a trial. Hopefully.
I'm excited too, because this isn't a topic that you hear about every day.
No.
It's not something that you're just like, oh yeah, all of this about an energy trial. So I'm excited to dive in and get all the fun tidbits from y'all.
Right. And we try to make it fun.
Yeah.
We think it's fun. Obviously.
It's fun.
That's what we do for a living. Yeah.
The trials that you hear about are not the trials that we're doing. They are not the ones that are covered by Court TV or later featured in Dateline generally. So,
no Johnny Depp and Amber Heard
trials.
trials.
No, not. Maybe unfortunately. I don't know. That seemed interesting. But no, so it's different. And I think people have a lot of questions and there's a lot of confusion too, because there aren't shows or, Law and Order that generally talk about this kind of trial.
so many expectations after watching something on TV and you think this is what it's going to be like to do a trial or to prepare for one. And it is not like that at all.
Yeah.
These are years in the making.
And I hope that, no one listening ever has to sit through any sort of trial for any reason. But I think if you find yourself in that situation, I feel like I'll be excited, or at least feel a little better to have some background knowledge of what terminology and what to do. And then I know before we started recording, also just some best practices on how in our daily work lives we can just be conscious of protecting ourselves in the company should anything arise in the future.
Well, and you're right to want to educate the audience and talk to the audience about these things, because you're right, knowledge is power. And there are things that if you know from the beginning, you can avoid making mistakes really early on that, you wouldn't have made if you had known. So we were going to walk through, to that point, kind of a few different scenarios that people would maybe find themselves in.
Absolutely.
In, the energy trial context, I guess you could say. But you or your company is sued.
Let's do it.
Just as a general matter, you or your company is sued. And I usually will kind of cover more from you're an employee at an energy company or you are running an energy company perspective. And sometimes Ashley can kind of cover more of, and we can talk about that given the differences sometimes in the kind of cases we have. But first thing off, whether you're running a company, working for a company, don't send emails about the lawsuit. Right? So you get sued.
Always the first thing is oh no, I can't believe this happened. And then you type off an email to the team, either potentially mischaracterizing something or saying something that is going to be twisted and held against you later. And you can't take it back once it's in writing, and once it's in email, it's
almost
forever.
Seems like it's common sense.
I
but
was just going to say that.
You're want to update them. And I'm curious because not all companies, let's say old age energy companies are probably still using email. Some might use Slack, Microsoft Teams.
Yeah, Salesforce.
Same thing.
Yeah, and all of that. I mean, Salesforce
still
messages.
Counts.
A direct message
don't
in Slack.
Pick up the phone.
Yeah. I know nobody likes to use the phone anymore, but really just pick up the phone and have a phone call.
And also if you leave a voicemail, that's also discoverable. So just call and say, hey, and then maybe send me back. Call me when you get this. But you don't have to put, the subject matter in. And that's particularly important, I think, for managers and things because, and even just as any employee working for a company, there's privilege concerns, right? So you're protected and your communications are protected if they're with a lawyer and you're getting advice. But, the message to your buddy down the hall, oh my God, in response to the lawsuit is not privileged.
But that brings up a good point, which is get your attorneys on board ASAP.
Yeah.
First thing you do when you get served with a lawsuit is get your attorney, because that allows privilege to attach, meaning attorney-client privilege and work product is going to prevent a lot of things from being discoverable, but you have to hire the attorney for that to apply.
Right.
So do that first. Also, allow them to help you capture what it is you want and need to say to your employees. If you're the manager speaking to your sales force or your engineers out in the field or whatever, make sure that you run that by the attorney first so that nothing can get you in trouble later. And then similarly, if you're reporting up to a board, same thing, because privilege doesn't always attach to every single communication you have about a lawsuit. And so you need both of those things going in both directions to be exactly what you need them to be and nothing extra.
It seems like when it comes to law, trial aside, but just having a lawyer, whether it's in-house counsel or a service that you hire, I feel like it's always like better safe than sorry.
Mm-hmm. Oh, yeah.
You know, like, I feel like as we've grown, we've started sending more and more things to our lawyers just to like, hey, can you put eyes on this?
Yes.
We just want to make sure
and I would
we're
say
protected in the future.
That's a perfect example of an important point. And she said, hiring counsel, that was so important. But even if if you have in-house counsel, if your company has been sued, and that isn't just because we're outside lawyers, it really is to protect the company.
Yeah.
But you really need, the in-house lawyer really should not be handling the lawsuit. I mean, as a general matter, even if you think it's going to save you money, it can create a lot of issues. And generally, to your point, having independent eyes, having somebody else looking at it. And another point to Ashley's point, I would say is, so you hire lawyers, say maybe, a little down the road, you realize maybe I made a mistake and I should have hired somebody else. Mm-hmm. You can change that.
True. Yeah.
Yeah. We come in all the time taking over. No, it does. It happens all the time. It's either not a good fit or the prior counsel isn't handling the case you went to have the case handled that way. And so you can reach out and find somebody else that's a better fit for you or is going to do things the way you want them done. It happens all the time.
Maybe it's also because the case itself changes. Like you think this is a case that we're going to settle, and then all of a sudden you're not, and it's nasty, and you're maybe going to have a trial. The lawyer who, was maybe going to be the right lawyer you thought to get you to settlement or whatever isn't the right lawyer to try the case.
Yeah.
So, I think having an open mind that you're not somehow forever, married to that decision or even adding additional lawyers who can add something else to the team. And we work with other firms all the time. And I enjoy that actually the most is having, co-counsel. So
yeah.
Fun.
And you have different skill sets. Every attorney has different skill sets, just like everybody out in the workforce has different skill sets. And sometimes you need to rely on one for one set of issues and another for different issues.
No, that makes sense.
So then moving on from, I guess, like you received the lawsuit, a tip, like one topic that comes up a lot and I think is confusing for people because you really never see any TV shows about this, but is the deposition. And if anybody, maybe has been divorced or something like that, they may at least have an idea of what that means. But you're asked to say you have to go under oath. There's a court reporter there and the lawyer for the other side gets to ask you questions. You have to give testimony that's basically the same as any testimony you would give in court, meaning like under penalty of perjury. Yeah. So obviously it's serious and it's really stressful when it relates to your job.
Is this like step one? Like you get served a lawsuit, step one is it?
That's probably like step 2 or 3.
Okay.
But it's very early on in the process and it'll go for probably like a year because you don't.
It is called discovery. And so that includes depositions, which is talking to people under oath. And it includes also gathering documents, sharing documents, exchanging documents, which we can talk about too. But the scariest, at least from, you're working at an energy company, running an energy company is, and we know this because we have to talk to these guys all the time. Yeah. They're like, oh, do I have, I have to give a deposition. And then if it's about my job, like, what if I say the wrong thing? And can I say I don't know? Like, if they're asking me something about my job or about the company, like, should I, if I say I don't know, am I going to be in trouble in my job?
Can you say I don't know?
Oh, yeah.
Okay, yeah, I would say I don't know all the time.
I know. Please say I don't know. No, I'm joking, but I mean, but truthfully, and this goes to our point on kind of the deposition process that you or your company, you have to give depositions in a lawsuit. You as the individual are entitled to be prepared, and your lawyers should be preparing you and making you feel comfortable. And I would always tell witnesses and people listening that if you're ever ask questions. Ask questions, and specifically, you can say you don't know. You're not there. And this is my biggest tip to people who find themselves in the position of having to give a deposition, either for their current employer or relating to their former employment. And kind of energy trials we have, you aren't going to win the case for the company, so don't try.
Yeah, I always tell people
it's kind of like stay in your lane,
not lose.
Yeah,
the job is to not lose.
Yeah.
It's not to win. You're not going to like score any points. So you don't have to know everything.
It doesn't have to be perfect.
I don't know is a very appropriate question. If it wasn't within your line of command, like within your scope of duty, something you did, a document that you are familiar with, you don't know. Because the guessing is what they, a lot of the time you're trying to get the person to over offer or talk about things that maybe they
don't really know about.
Right. And that was like, I feel like that's what people like slip up and like offer little information that they probably
because it's
shouldn't
awkward,
be
just like in this podcast.
Yeah.
If all of a sudden if I was supposed to be talking to you guys and we both just sat back and stopped talking and looked
I feel
at
like
you.
people get nervous and they just talk.
Like, aren't you going to say something? And I've asked you about your job and you're like,
I would
I don't know.
overcompensate. Yeah. I'd be like,
right?
yeah, I mean, I don't know, but I will tell you.
Yeah.
Right. And I'm like, and then if you say, I don't know, and I act incredulous about it, like, you don't know?
You've been at the company
And then,
for
and then we
years.
sit back, you're going to be like, well, maybe I do know something about that.
Yeah.
You know what I mean? That's
Is that tactics they'll use? Like, a lot of facial and, okay.
There's
I
definitely
use silence. And you can use incredulousness. You can use
Just staring at them.
Staring at them and not saying anything. Acting like you're reading from a document when you're really not, so that they're nervous.
This sounds so scary.
Yeah.
right.
It makes
It's
me
like,
so
are you sure
uncomfortable.
you have never said? And then they're like, oh my God, they're reading from something. So I've definitely said that. But usually I don't play those kind of games. Like if I am reading from a document, I'm reading from a document. But you do want people to talk. I mean, to get the witness to talk, you need to know everything that they could say at trial. And it doesn't mean it's all going to be used, right? Yeah. The lawyers will fight about that later. The lawyer fights are really the most entertaining part of deposition. So I would say, if you find yourself, at least know, if we're involved, I don't know, in our kind of cases, is at least probably going to maybe be entertaining.
I will say, but it's going to be tiring too. A deposition is very tiring. It's 7 hours on the record, and you take breaks. So it's actually more like 8.5, 9, or 10, depending on how many breaks you take.
Do witnesses come and go?
No.
Or they say
it's one person in the chair
for
7 hours on the record. Mm-hmm.
Oh my gosh.
I hope
we never get sued.
I know. I can't even imagine being asked. I mean, do you ask? You have 7 hours worth of questions, or you just keep?
It depends.
Not
like
always.
So I've had I tend to use all my time, but I have had witnesses where it's like maybe 4 hours. But if it's like an expert on like a smaller issue, or if it's a third party or somebody who's like not so much involved, but typically like there is a lot to go through, at least in our cases. I mean, you're talking about, I don't remember how many hundreds, I don't know how many gigs or whatever of documents in like a recent class action I had, but you're talking about they can't even be put on hard drives. I mean, massive amounts of data and stuff. So just dealing with a lot of information. And so it's really detail oriented, of course. So, and then I would say if in the deposition context, if you're in the company's position, say you're the VP of land, right? And you're asked by the in-house lawyer, hey, we need to find somebody in land who can testify about, these leases or, whatever. Then there's the decision. And I think that that's a decision you talk about with your lawyers, but who should give that deposition,
Yeah.
You have to choose wisely.
Yeah. Is it the landman who like actually went out and negotiated the lease? Is that actually the best person? Should it be the VP of land and maybe speaking more for the land department as a whole? Or, is it really important to have, that landman's testimony about his personal discussions with the landowner, right? It depends. And that's always the lawyer answer, but being thoughtful about who is giving a deposition.
Because you want somebody that's going to be able to answer questions correctly, not volunteer too much, not want to fill the silence with stuff that may or may not be relevant. And so you do have to usually interview a variety of people before you settle on, okay, I think this one is the best person for the job, at least for this case.
Unless it's like a case where it's like you're all like royalty cases that I do, upstream cases. I mean, there's, the accountant at the company who handles, the calculation and payment of royalties, right? That guy, like, he's that guy.
Yeah, he's
basically every case,
and
it becomes a joke. But that's the other thing with clients that is really interesting and helpful is like you can really help your employees and your colleagues and explain the litigation. I had one time, and this guy, he's just fantastic and is now like controller, of a independent oil and gas producer, but I finally explained, I got him on the phone, and sometimes that's hard as an outside counsel to get one-on-one with, just like a business guy at the company, but the company was like, yeah, no, talk to him. And I explained what we were trying to prove. So there's like historical payments and, what we were looking for. And he was like, oh yeah, no, but those wouldn't be there. I didn't know that we were trying to prove payments from this period. I can find those. Let me get that for you. And within like an hour, I had a spreadsheet like proving, the lesson being like, have faith in your, like, give them some contacts around like, what do we need to show as a company? And like because they can be so helpful. Like people in different departments and different things in charge of different records, or, maybe it's just having more historical knowledge. If it's a company, that's been around a long time,
right?
They've gone through different systems, different management, right? So having people who know where, older records that are hard to find. So I don't know. But I thought I was just so impressed by that. And
I think it goes both ways, right? So it's important for the lawyers to ask good questions of the team that's involved in the lawsuit at the actual company so that we get the information we need to be able to defend whoever it might be. But at the same time, I think it's also important for the people at the company to ask questions too, so that they understand from the lawyers what matters and what's important.
Right.
And there's obviously a meeting in the middle where everybody gets to understand what matters, where the documents are. Don't delete anything. That's probably another thing we should talk about.
I was going to ask about that. Like, I know companies they use different tools to store data and files and things. And is there a time frame in which there's a safe zone, or do you really recommend like, don't ever delete anything, like back everything up so that as far as it can go back, it goes back? So if you find yourself in a situation where you need something from, 10, 15 years ago, you've got it.
So the rule is if you're anticipating being involved in a litigation, you need to stop or suspend any data destruction protocols that you have. Otherwise,
that relate to the litigation.
Yeah.
Right.
So not your normal, auto delete, whatever can go on but you have to segregate. And so a lot of times that's identifying custodians, but meaning the individuals within the company that are going to have relevant communications. And typically it's like freezing their inboxes or et cetera. So there's ways to do it,
right?
To where you're not like freezing everything, but it can be complicated and it needs an assessment on the front end and fast.
Yeah. And there are a bunch of companies that we work with all the time that actually do this whole process to make sure that documents are collected in a way that we can use them in a litigation. You have to maintain the metadata, meaning all the stuff that tells you when the file was created, when it was last modified, who created it, who modified it. All of those things have to be maintained as well. And so there's companies that specialize in this that make it as seamless as possible, as painless as possible. It's never painless, but at least they try and get it out of the way pretty quick so that it's not something you're dealing with every day.
Yeah.
And then of course, apart from the litigation itself and what may be preserved, there's different laws that apply, especially in oil and gas and the kind of cases in my clients, different state laws sometimes about how long they have to maintain lease files. Even apart from, litigation, there are certain obligations on at least energy companies and those remitting royalties or who have landowners in maintaining certain files. So sometimes, that's kind of even outside the litigation, but worth knowing. And gathering documents is another big topic that we were going to talk about. And that kind of relates to, again, what Ashley was talking about, which is a lot of times referred to as a litigation hold. So when you get sued, the company will send to the people that were involved in the subject matter, whether it was a project, contract, whatever, an email typically, and it includes a hold notice saying like, we believe there's going to be this litigation, this is the subject matter, and that you would have communications, do not delete. It has very specific instructions, like, and they have to respond affirmatively that they will abide by. I mean, it's very serious.
I would
there's
be
like
so
big
afraid.
time consequences if stuff gets deleted. A court can say, we can assume that whatever was going to be in that document was bad for you.
Yeah.
And so we can instruct the jury to assume that.
I would be so afraid I would
really
accidentally.
I know.
Just like in my day-to-day like workflow, accidentally delete something.
I know. And the thing is that a lot of companies that, that we represent, not all, but a lot of them, they have IT departments and it's like handled internally and in an electronic fashion that, that thankfully we don't really have to worry too much about. But the other way of getting documents that we haven't talked about is by subpoena. And so that's a word that people will hear a lot, or maybe a person who has the misfortune of receiving a subpoena. And a subpoena can ask for documents and sometimes the deposition. But typically, if you're being subpoenaed, a lot of the times, and this happens a lot, but energy companies will receive them. So your company is being subpoenaed maybe for records for use in somebody else's lawsuit. And so you can imagine that's kind of scary.
Yeah.
But you also sometimes think, and I've seen this and heard this and talking to clients about actually their best practices, because one of the major oil and gas producers if they receive a third party subpoena, outside counsel, not in-house, is handling it. If the company is being subpoenaed, somebody else's dispute, just because you can end up like getting yourself involved.
Yeah.
And also there's other issues. So if you get a subpoena asking you for all of these documents, which sometimes in my cases, maybe, you're getting a subpoena as a company and they want all of your sales contracts for like certain volumes of either gas or NGLs or whatever under like NASB contracts, which are like standard, of the sales contracts in upstream and downstream oil and gas, right? Those are confidential. Everybody knows they typically always contain confidentiality provisions, and they all contain, in my experience, sometimes different, like you have to give notice before you disclose a document. So the thing is, you want a lawyer before you go produce documents in response to a subpoena. You do have to worry about, are you breaching obligations
to your company,
to other parties, to those, if it's contracts. Like, what about the other party to that agreement? Are they okay with you giving this contract? Are you even allowed to? Under
What
the
happens
contract?
if they're not? They just can't hand it over?
I mean, we have actually had to respond to requests stating that we could not. That the agreement that they were requesting said absolutely under no conditions do you disclose it. It would require a court order, and typically a court will not order.
Yeah. It depends on the language of the contract. Some of them are like, you have to give us at least 10 days notice. And if you don't hear from us, then you're free to disclose it. Or the company that doesn't want it disclosed has to file a motion for protection within the court saying we don't want to produce it. Or sometimes it's the other way around, where the party requesting it has to file a motion to compel the document be produced. And at that point, once you have a court order, that usually is enough to get the document if you have to go that far.
But you really do want an outside lawyer to that point. As you can imagine, making the evaluation of, do we need to move to protect some of the documents that they're asking for? And you want to generally be cooperative. Of course, you can get in trouble if you receive a subpoena and you just ignore it. So don't do that.
But you also have to respond pretty quickly. So you don't get your subpoena and then you go, okay, I'll think about that later. And then you put it off to the side and don't think about it for a month, because then your deadlines have passed and then you can't object. You can have sanctions assessed against you.
Jeez.
So it's important that you actually, when you get a subpoena, you look at it and do something with it pretty quickly.
The other tip, I guess I would say, is if you get a subpoena and it relates to, say, your former employment.
Oh, that's a good.
Call your former employer's lawyers. They're going to be listed on the subpoena. Call them before you do really anything else. If it relates to the same subject matter as your current employment, I would also inform my current employer that I had received a subpoena about, my former employment. But definitely call them before anything else, because the other thing is, depending on the agreements that you may have signed when you leave a company, you don't want to misstep and breach, those agreements with your former employer. And you also, if you can avoid getting involved, avoid getting involved.
Yeah.
So, and they may be able to just talk to you and ascertain you don't have any helpful information and convince the other side that they don't really need to talk to you.
Yeah.
So
this is really helpful, I think. Like, it sounds like a puzzle. Like, do this before this and check this box. And like, you don't really think about getting sued ever and like what this steps. That I feel like that's why for me, like, anything around this is very overwhelming, because I'm like, there's so many things that you just as a random person, not an attorney, don't know. So this is very, very helpful. Do you have more tips?
Well, I was just going to probably lay out how the course of a lawsuit works for people that don't know, so you can know that, okay, this is the thing that happens immediately. This thing is 2 years down the line. Yeah. So lawsuits can vary in length. I would say mine are typically 2 to 4 years long. Jeez. And, it really does depend. I've had one that's pending for 7 years, and I know that Lauren spans the full
I feel like mine are. I feel like mine are on average over 5.
Yeah. When you think about like the average person in any job role, especially, I mean, I'm turning 33. You're turning 33. So like, I think people our age, millennials are job hopping so much. Like people rarely even stay in jobs longer than maybe 2 or 3 years. And that, on y'all's end, you have cases that are 5 to 7 years long.
Yep. Yeah. The witness may turn into a third party halfway through, which can have disastrous consequences too. So if you think about that long time span of how long a lawsuit can be pending. So the first thing is you get served with that lawsuit. You need to immediately contact your lawyer and start figuring things out. And you immediately need to stop any document destruction policies that you have in place. Then shortly after that, discovery begins. That's the depositions and the document collection process that usually goes on for a long, long time. And then towards the end, you have something called summary judgment, which is basically you telling the court, a jury doesn't need to hear this. It's so cut and dry. You can just decide it, judge. Right. And then if that doesn't work, you end up at trial. Mm-hmm. So that's kind of at a high level.
And then
the
how long
stages.
does the actual trial last?
Oh God.
Ooh, it can be, if you're in a little misdemeanor court, which I don't ever do those, but if you're in a little misdemeanor court, that it's usually like a half-day trial.
Yeah.
Okay.
My trials typically last a week or 2 weeks, but they can go up to a month or longer, just kind of depending on what it is.
I feel like the shortest trial I've had is a week.
Yeah.
I've had 2.5 week trial, and then the jury took over 2 weeks.
I can't imagine that. I've never had a jury come back more than like a couple of hours.
And it was so funny because every day I would come in, I'd be like, this jury has been deliberating this many more hours than the O.J. Simpson jury deliberated. And everybody was like, thanks for that, Lauren.
That's great stat.
That's helpful.
Yeah. Why would it, like, how long would they get forever if they just like couldn't come to
at some point is the judge
decision?
They usually will send a note being like, is there or the judge will kind of check in, is there an issue? And that was not the case. But anyway, it was really crazy. But then I've had some where they're out for maybe an hour and you're like, whoa, how did they talk about anything?
It's interesting. So if they like 2 weeks long, they're leaving and coming back. I thought you couldn't do that. Like I thought you had to decide in that room. So like outside media, whatever.
Yeah.
Can't skew.
So you've still been instructed by the judge that you're not supposed to Google anything. Mm-hmm. Okay. Don't check social media. Yeah. You're allowed to go and sleep in your own bed, but for the most part, you shouldn't talk about the case.
And you shouldn't drive by if it's a site. Like for us, it's like an oil and gas lease or certain wells that like don't go see the site. You're not supposed to do like your own investigation, but they all. I mean,
yeah, like how can you not
check
social media?
They're not supposed to go and Google the lawyers, and I'm like 100% positive they do because I've come back and seen people look at I'm like, yeah, they looked at us. Yeah. So it's funny.
Do you feel like, and I don't even know if you have an answer for this, but I would think if I was a juror on some sort of energy trial, just knowing how many people don't know anything about energy, I feel like it could be very overwhelming.
Yeah.
That's our job, though. We teach it in bite-sized ways with lots of fun graphics and things to make it both interesting and fun to learn, because that's the best thing you can do is teach a jury why you should win. Mm-hmm. So when they go back for 2 weeks into that jury room to deliberate, you have an advocate on your side. Mm-hmm. It's like, no, remember, she said XYZ. Don't you remember that chart or that graphic? And
I'm just such a believer in the trial process and that a jury, if provided the information, like given, both sides' stories, will generally come to the right conclusion if they're allowed to see everything. And so, but having so much faith in that. And to me, I'm always like, we're going to do the coloring book of this case.
Yeah.
And I like storytelling. I'm big on like kind of Johnny Cochran, but like kind of rhymey things, like colloquialisms, themes. You know what I mean? And repetition, right? And then looping, right? But, you know your client's story and you're there to tell the story. And yes, you're going to do so through, maybe what are kind of boring looking documents or whatever. But the story itself isn't boring, right? And we're going to bring it to life. In the end, if you can teach a jury, like they get to go home to their family and they've learned something they didn't know before. They like that.
Yeah.
And they feel empowered by that. And I actually do think a lot of people are interested in oil and gas.
Oh,
especially in the places
yeah.
we're trying cases. Like,
That's what I was going to ask. The location really depends on
like West Virginia,
how,
Pennsylvania, Texas.
Yep.
Like people, these are places like with oil and gas industries, and you'll see them sitting there sometimes like,
well, because lots of people don't know. Kind of, you hear the words fracking or downhole tools or slick water and all of these things that are used to actually get things up out of the ground, and nobody knows what those are. And you can actually paint a picture, physically show them the device, show them how it works, and it's fascinating for most folks because you're never, if you're not in the industry, you're never going to know what that is unless somebody teaches it to you.
Right.
And then sometimes they're really surprised too, because a lot of, at least in defending energy companies, a lot of times there's what we believe are crazy allegations of fraud or different like conspiratorial type conduct. And, you know, it's a kind of eye-opening, I think, for the jury sometimes, because a lot of times we run through, you know, companies' audits, right? How many times they're audited, all of the rules and regulations that apply to energy companies and every single thing that they're doing, every governmental agency. So, I mean, I think they're like, oh, I mean, just from a common sense perspective, start some of the conspiracy or like, you know, thoughts just naturally kind of fade away. And I think that juries are actually surprised by that when they leave.
Yeah. That's really interesting. I actually want to be a juror now.
I want to too. Let's try to get on the jury.
Every time I get called for jury duty, they end up like setting, I get an email or whatever a day before, and they're like, you don't have to come in tomorrow.
I've never gotten called for jury duty.
I've never gotten called either.
And I think the one time I did, I had a baby. So like,
yeah,
I had my out. But I did teen court in high school. And I love that. But that's a little different. It wasn't
I think I got called like 3 times in like one summer. I was like, I must be at the top of their list. Like it was, you know, nothing for 20 years. And all of a sudden like 3 in a row. I'm like, can y'all leave me alone?
You know what would really be fun? And if I ever get a chance to do is I'm going to sign up to be like a mock juror.
Ooh.
So in our cases, a lot of times we'll have like a mock trial of the case.
Can we
and
come
you
be
pay,
mock?
you pay people.
We want to
pay
come.
people.
We'll be your mom.
To come in and they'll sit as a jury. They deliberate. A lot of times you'll maybe even have more than one jury. I had one where we had like 4 simultaneous juries and they would break out into the rooms and you can listen. Oh, it's so funny.
That is
because they'll talk about you.
Yeah.
Or they'll learn about your clients and we're like, oh, but it's funny.
You learn the most about your case though when you're doing a mock trial like that because you have your theme and your story and your documents that you want to show people. And it may go over great,
right?
But it may not. You're like, oh,
you
like
find
the
holes in your story.
Like they're totally confused. Like they missed that totally. Like it's like related to oil and gas in Syria, and like one jury just kept being like, "Where is the Syrian government? Why are they not here?" And we're like, like it was a question like we never. Why would you be asking that? But it like raised a point in our minds that maybe we needed to explain. You know, that it didn't to
involve.
the real jury that like it doesn't involve them and they're not here. And even if we wanted them here, like good luck getting them here just to eliminate any idea.
Yeah.
So it kind of can show you some of the crazy things or ways things can go off track. And so you can know to stop them.
Right.
To keep them on the right track.
Yeah.
Yeah. Well, this kind of ties into like before we wrap up, I want to know some of your favorite stories. I know you can't divulge anything confidential, but you know, anything crazy that's happened at trial or
Ooh, my favorite,
any good stories.
My favorite was that we were waiting for a jury to come back and we were the plaintiff and we were asking for over $100 million. And I was the one that put on the damages expert to make sure that all the calculations, the jury believed them and that it was exactly what we were entitled to. And during deliberations, the jury sent out a note and asked if they could give us more than what we had asked for.
They were like, 109 isn't enough. We think that they deserve more.
And the best part of these kind of stories, and I wasn't involved in this case, but the best part of it is when the judge gets a note from the jury, what he does is he calls everybody because you're waiting nervously, and then he calls everybody and he's like, we have a note from the jury. So everybody's like, oh, so all the lawyers run in, and then can you imagine? On the other side, they're like, they want to know if they can give them more money. On the other side, you're like,
how do you not react? Did you react? I would be like,
I would scream, I think, in like a good way. Like a good
right? Well, like, we always tell people when you're at trial, you have to maintain a poker face the whole time because the jury's looking. So even if you get stabbed in the heart with some like bad document or testimony, do not make a face because that just telegraphs what really happened in case they didn't catch it.
And especially as a woman, I'm going to be honest, because a lot of the times we're the only woman presenting in the trial as an attorney. And it's just true that when you're different, there's just more attention paid to you. And particularly facial expressions, things like that.
So y'all are really good at like not having facial.
No, I have no poker face. That's
okay,
so
I'm like,
I feel like I'm always the one who like the jury was like would look at me because I'd be like, but I mean, but at times like that, like with the question or something, and I particularly like when the jury comes back, I always am telling everybody, I'm like, we make no reaction, do not say anything, you just keep your head down, whatever, and so there's definitely certain times when you don't, but I'm not the best poker face. She knows that, so I can't lie in front of her. My stories are so insane that it's hard to even know where to begin. But including ones that made national news because the guy that held us up at trial. But putting aside,
I remember that the guy that brought a gun to the trial.
Yes, yeah, and so that was probably the craziest. And I hope the craziest that I ever have. But I will say, arguing for that we believed the judge had a conflict, and this was in a different case, in a very rural area. We had to go and argue to that judge why we believed he was conflicted out, and he had spoken to the media and like he hated us, and the tension in the room, it was just, I'll never forget how tense of a situation it was. But one thing that I will always stand out to me is, so we were the defendant's lawyers. So the plaintiff's lawyers in the cases were coming in. No, judge, you're so fair. There's no conflict, right? The plaintiff's lawyer shows up with a tie covered in fake dollar bills.
Why?
Which is like allegedly kind of like a sign of it's like known as like the money tie, meaning like bribery. And he shows up to the DQ hearing like, you're not conflicted, judge, with this money tie on. And I was just like, how inappropriate. It was just so insane.
That's so weird.
And so crazy, like stuff like that. But yeah, the one where we waited like 2.5 weeks for the jury was one of the craziest. We were playing Uno. I mean, you run out of things to do. Like,
so do you guys just show up every day?
Every day. It would be like the 8 to 5. We're like, oh my God, how are we going to kill all of these hours today?
Yeah, you're not even allowed to like show up comfortable.
Wait, back to the judge. Who's over that? Like how can you like,
how can a judge help?
Is it the judge himself being like, you're right,
I'll dismiss myself?
Oh, I know. That was really what they made us do. And then it went up to a judge on the higher court who decided it. And with that judge, they agreed that he should be disqualified. I mean, during the hearing, he compared our team, so counsel and my client, as a murderous orphan who is coming asking for leniency. And I was like, very confused as to who was the dad.
That is aggressive.
And how we killed him. But I mean, these were the kinds of things where I'm just like,
that's aggressive.
How do you keep your face?
I mean, I think I was just like, because I'm like, who's the dad? Like, I mean, who were our parents that we killed? Him? I don't know. I don't know. It was so weird. But so funny things like that. And those are some of the, but waiting that jury to come back for so long. And then the glory of that one was they came back. They did have a number in the blank. But what a lot of the times people don't get is like the jury charge, and the questions are really complicated. Okay.
Yeah.
There are questions in there that will sometimes mean even if you are awarded money, you're not getting any money. Like, statute of limitations. Like, if you should have known something a certain amount of time before. So we had questions on there that were like, when should they have known? Or like, did they know by then? So those questions, and my hands were shaking. I was so excited because I knew by those answers, the rest didn't matter.
Yeah.
Because they should have known. That means their claim was barred, meaning they get 0.
Yeah.
And so then they get to the number blanks though, and she still reads, the answer of like how much money was awarded. Well, the other side, the plaintiffs are like freaking out. They're not lawyers.
They don't understand they're not getting anything.
And you can see their lawyers are like,
they're like, sit down.
Yeah. So anyway, so it was a win, but man, a painful one of waiting 2.5 weeks.
Yeah.
Of course. So anyway, but we love talking to y'all.
Yeah. Let's wrap up with 2 important questions. Number 1, what do you guys think is the most common? We usually ask like the most common misconception in energy, but I would say for this podcast, the most common misconception as it relates to like energy law.
Ooh. A common misconception from, I guess, whose point of view? I will sometimes say from, the energy company's point of view, the idea that you can just settle, litigation instead of having to try cases, and that is maybe a sustainable strategy because in my experience, it does not work out that way.
I was going to say almost the same thing, which is you may have to take a certain position or produce certain information in a case, not for that case, but because it could have long-standing consequences for other cases for years to come. So it's like we have to turn off the water tap now because otherwise we're going to have a flood of things later. And so it's really important to figure out, okay, we're about to get hit with 15 of these lawsuits. What do I need to do now in the first one to make the next 14 more manageable or cut them off?
Yeah.
And they're copycats. I mean, like plaintiffs, they file certain lawsuits, wait and see how they go. And then, they do generally work together, the plaintiffs bar. And not that we aren't on the plaintiff side of cases too, but at least in, upstream litigation against energy companies, those guys typically talk, they work together, they know, they're hearing what arguments are working. And that's true in the climate litigation too.
Yeah.
Kind of changing arguments, trying to see what's going to work.
And I would say though, the other thing is just thinking I'm not going to tell my lawyers about thing X because it shouldn't really matter and I don't want to have to talk about it. And it inevitably will become the focus of the trial. And it's like, I can't help you avoid the landmine if I don't know it's there. So you have got to tell me, we're your lawyers. Everything is confidential. Please, please just be 100% open and honest, because we can oftentimes make a plan that will eventually avoid the issue you're worried about. But I guarantee you, if we don't know about it, it is nearly impossible to avoid it.
All right. Last question. Why should we care? The listeners, the general energy professional population, why should we care about energy law?
It affects everything you do every day. I mean, there's just no getting around it, whether it's regulations or whether it's you're getting sued or whether...
we didn't even touch on regulations.
Yeah. It affects everything you do every day.
And I think I would say that given where we're at, near, I guess, the end of what you could say, the shale revolution, and I think a lot of transition in the energy industry, but the changing social, economic, political pressure for sure is making it's more costly, right? To do business and to make a profit, for your shareholders and to maintain a robust business for your employees and the environment. But I will say that not keeping tabs on litigation and fighting when you need to fight to stop the bleeding will, and I have seen it, will bankrupt your company.
Jeez.
In combination with everything else. If you don't, and if you are in a certain state or region and you start paying in your deep pockets, they will try to bleed you dry.
Yeah.
They will.
Yeah. It'll be death by 1,000 cuts, but it
just like
still
the name
ultimately
of the
results in the death of the company.
Yeah.
Well, thank you guys so much for joining us.
Thank you.
I know this is fun.
So
Y'all will have
fun.
to come back and we'll do another topic. I love this.
Yeah. It's so fun.
And we also we do an event called Energy Tech Night. It's for energy tech startups. We actually are doing one in Fort Worth this year.
In.
So we'll make sure to send you guys the info so you guys can come hang out.
Thank you. Always so fun. Thank you all so much.
Awesome. Thanks for coming.
Bye, y'all.